Greetings, everyone. I, Khushbu Chavla from Team Legal Vidya, welcomes you all to the 19th class of 9-week certificate course on advanced legal drafting by Legal Vidya. Now, I would like to welcome our honorable speaker of this course, Ms. Shivani Gupta, to take the session forward. Welcome, ma'am.
Good evening, Legal Vidya. Good evening, participants present over here. I'm just connecting in a second, just sharing the screen for today's session. And today's session is also about one more topic in the civil proceedings only. Just sharing the screen, just wait for a second. Okay, I'm just sharing it. I hope you all are doing good, by the way. Today it's a easy topic. Very easy topic. I have already shared the PDF in the group. I think you might have opened the PDF, then you would be acquainted with what we will discuss today. Wait for a second, it's a network glitch. The file is not uploading on the screen. Wait. And today we have to discuss two drafts under the same order with the different rule. An error has occurred while sharing the screen. आ रहा है. Wait for a second. Just trying hard. Does the screen is visible to you all now? Okay, Srishti Ranvijay Soni, thank you. Yes, so we are starting with today's topic. That is, first of all, we have to discuss two applications today. Am I clearly audible? Actually, sore throat is there. That's why a little bit of the voice would be lagging, but we'll try to. Yes. So today's session, dear participants, is about, first of all, is about the order number 9, rule number 7, followed up by the order number 9, rule number 9 under both the orders, under both the rules that must be discussed with the section number 151. So before directly jump into the draft, I would like to let you know about little bit about the, wait for a second. Where is my screen? Yes, due to the network glitch, actually Wi-Fi fluctuation is there. That's why I was disconnected from the class. Just wait for a second. I'm just sharing the screen. Just wait. My screen is visible. Actually, don't know what is happening. Okay, wait. It's like okay, okay. Please confirm it because it's infinity mirror on my screen now. Is it visible now? Oh, okay. Yes. It is visible now. Thank you, thank you, thank you, thank you. Please, please, please. You can put your hands down. Yes, yes, got it, got it. Okay, yes. So I was talking about that in the today's session. We will discuss about two drafts. Two drafts, namely, first of all, the draft regarding order number 7, rule number, order number 9, rule number 7. And second is order number 9, rule number 9. We will discuss both of the drafts. But before directly jumping into what's the format of the draft, I have put the draft. Before that, we will like to learn about some law for the same. For example, we will start with the a very introductory part about the same, that what is the provision, what is the law says so about the order number 9 and the rule number 7 and rule number 9 accordingly. When we discuss about both the things, then there are certain other rules also. Under rule, order number 9, rule number is 7, 8, 9, 10, and 11. These are the four rules that are being discussed, and there is another concept that is also being discussed, that is the ex parte decree against the defendant. So these all are the things we're gonna discuss today. Now we will start with the order number 9 of the CPC. Okay, so this you can also just open the BRL and go through, but it's my duty just to explain you everything. So listen carefully. What happened if we, first of all, we are all are aware that there are two parties in a suit. Already we know that one is the plaintiff and the other is the defendant. When the both parties must be there during the hearing, then what happened if in any case any of them is not present, then what would happen? Then in any case, order number 9 is applicable. Order number 9 is particularly providing any rules for the appearance of the parties in a suit and also give the consequences for their absence. Now, according to the rule number 1, it is said that both parties must be present either personally or through their pleaders in the court on the days fixed in the summon issued to the defendant. First thing is this. Order number 2 is somehow is like it's found that no summons were issued to the defendant due to the plaintiff's fault, that the suit will be dismissed by the court only. Now comes a very important part. This important part, because today's discussion is more about the rule number 7, order number 9, rule number 7. So we will focus upon that. Order number 9, rule number 7 particularly say that the procedure where the defendant was absent in the previous hearing but appears in the subsequent hearing and gives a reasonable or good cause for his absence in the previous hearing, which provided that where their court has adjourned the hearing of the suit ex parte and the defendant gives a good cause for his absence, the court or the terms and conditions may hear him and deal with the suit as it had appeared on the date for fixing. So there was a one case law also for the same, but no need to discuss the case law. It's a East India cotton manufacturing case, but there are certain ingredients also, the conditions also that must be fulfilled when we are applying the rule number 7 of order number 9. The defendant must not have appeared on the previous date for fixing. He should have to give the response reasonable cause for his previous absence. Court must have adjourned the ex parte hearing. The court has discretionary power to order him to pay the cost. So these are certain conditions. These are the certain essential grounds that are necessary. Now the order number 7, order number 9, rule number 7 also states related to the other rules. That is the rule number 8, rule number 9, and rule number 10. But today our topic is all about that what it is saying under the rule number 7. So this is what the rule number 7 is saying. So I think you must be acquainted with the law. Now, if anyone having the any question in the law, then please put in the chat box. But now we will discuss the draft of the same. Draft I have shared with you on the screen. It's mentioning like in the court of Mr. This leading senior civil judge, that is our Rohini court, Delhi. In the Delhi there is a Rohini court. Now the case number is this, and in the matter of first of all the plaintiff and the defendant are being mentioned, and then there is a certain a date that is being also mentioned. Now what happened? Now this application on the behalf of the defendant under the order number 9, rule number 7 with the that is we will have to discuss with the section number 151 of the CPC, and the order is just like setting aside of the ex parte order. Now we will mention that and ex parte order was mentioned released on which date. We will mention that also. Now it would be followed up by respectfully show it the present case is pending before the High Court and listed for this day. The language can be changeable, language can be altered. There is no as such thing like that you have to mention these words only. This is only a sample paragraph or a sample thing You can refer, you can take the reference from the those same simple samples. Now, on that, on the husband of the plaintiff with Miss this is the take care of her daughter's factory. And first of all, we will mention about the facts of the case, and the facts of the case are mentioned in like I'm studying. Some court officials reached at the previous place of the plaintiff already sold summon to the defendant, and the current owner of the property conveyed him from the Rohini court staff searching for the defendant. Defendant has been discussed with his lawyers. His lawyers appears before the High Court on this day, and also filed a memorandum of appearance and inspected the court file on this date and got the above mentioned facts and the cases. Now these are the things that we have to tell the court about what is the current status, what is the thing happened before, and what's going on actually now, and what is the status of summoning, why there is non-appearance of the party, why there is a sudden appearance of the party. So these are a kind of a things that the person have defendant have to mention clearly. Defendant, the plaintiff has filed the case before the honorable court on this date and the listed on this date. On the same day, none of the appeared on the behalf of the plaintiff, and the case of put up by another date that will be mentioned here. Now that on the this particular date, the report was submitted before this honorable High Court that the defendant not residing at the given address, and thereafter the service was affected through the affixation, and the report of the affixation was submitted before this honorable court on this date, and on the same day the court was proceeded against the ex parte, the defendant, and the matter was put to ex parte evidences. So we have to mention about all the contents, all the facts or the circumstances of the case. On this date, the plaintiff witness examined, and thereafter the plaintiff evidences was closed by a way of statement of the plaintiff, and the matter was listed for advance ex parte final arguments. Now we will mention about that why there is no need to go for the advance ex parte final arguments. Then we will mention on this date the counsel for the defendant filed the memo of the appearance, and thereafter the file was inspected by counsel and found that the defendant was proceeded ex parte and the services was affected. So we will mention about these things also. Then if there are certain annexes, for example, in this case, annexes are like the attached copy of the application, attached copy of Aadhaar card, and so on. So this can be mentioned here. Now there is another thing that we have to mention is that the application is bound to obey the directions of the Honorable High Court. If there are any, then we will also mention the prayer, and the prayer is the most important thing that what we want from the code regarding the same. Sorry, it's like that respectfully prayed that the honorable court may be pleased to set aside the ex parte order that is being dated on this thing, and the circumstances mentioned here are this thing, and also in the interest of the justice. And these are the simple things. Then the advocate address, mobile number, email is there. Then we will mention the it's another I think now we will mention the affidavit for the same, because we are filing the application in the court. So affidavit is also being required. I think day before yesterday or the yesterday, someone was asking me about the affidavit also. Yes, now you can clear your doubts. The affidavit format I have also tagged in here. Only the deponent is the defendant. First of all, yes, the format of the affidavit look like this in the court. This is the format of the affidavit. If you meanwhile, if you people have any query regarding the same, then feel free to put in the checkbox. We'll take it at last. Now, now what? Does the tell me one thing? Does the affidavit is visible to you all upon the screen? I hope the affidavit for the application is visible to you all. Yes, these are the necessary part for the civil pleadings, and you have to file the affidavit also. In the affidavit, yes and no. In the affidavit, rest arrangement, got it, got it. Okay. Yes, and in the Honorable Court of this leading senior civil judge Rohini courts, and in the matter of this matter of plaintiff and defendant, then the affidavit would be marked as I Srimati this wife of a resident of present at a Delhi do hereby solemnly affirm and declare as under. Yes, the oath is given. Oath is given like the opponent is the defendant in the above mentioned suit filed by the plaintiff, the being conversant with the facts and the circumstances of the application, and I am competent to swear this affidavit, and the content of the application have been read over, explained to the applicant in Hindi, English, or whatever the language they understand, and fact mentioned are true and correct to the best of my knowledge. believe something like that, and then there this application is accompanying under section number 9, rule number CPC, rule number 7 of the CPC, that is being drafted. Then there their defendant sign will be there, verification will be there. Verification very important part. How many have you reminded that the verification? Okay, tell me verification, where we studied about the verification. I just tell you in the previous drafts also. Yes, where we discuss about the verification. I think the session is going monologue. Anyone? Where we discuss about the verification? Kindly unmute. If not possible, put in the chat box. And what's the purpose and utility of verification? Oh God, no one. Are where we discuss about the verification? Did you? I think you people don't do any kind of a revision at all. Yesterday I asked, we have discussed the verification, but I think I am discussing in the 17th class. Okay, what was the 17th class is about? I am asking about the topic. No one is doing the revision at all. No one is reading something. No one is aware of the facts. This is not done actually. Condonation of delay in filing the application for the revision. Okay, there we discuss about the revision. Oh, sorry, verification. And next, before that, we discuss about the verification. What is the purpose, utility of the verification? Anyone? I can understand this is an online class, but after the class is over, you have the PDF in your mobile. Then you can already go through what is being mentioned in the PDF only. Okay, you are not able to confirm the authenticity and the genuineness. Verification is required for any of the legal document. Okay, then Vijay, good going. But where we discuss first about the verification. Very first we discuss about the verification in the law. In the drafting specifically, not in the law. I think there might be some advocates also, so they would like to answer how this will going. This is a really very disappointing for me. Verification is a part of a plaint or the statement to state whether it's stated on his behalf is true or he also knowledge about it. Okay. Yes, Advocate Sakshal. Good mention. Everyone is just copy pasting the Google answers, but no one is able to tell that, madam, we have studied, talked about the verification when we started the civil drafting. And the very first part of the civil drafting was the drafting of the plaint. Now open the plain PDF and just go through. Then you will see yourself that important part of the plaint is the verification. Its answer is as simple plaint. How many of you are aware of that? अभी किसी को remind हुआ ये? Actually, I think sometimes the session is going monologue. Okay. अभी सबको remind हो गया. Good going. Now you tell me one thing. Is there any difference between the claim? These things I will discuss in the revision classes also. But you tell me, what is the difference between the plaint and the complaint? Are plaint and the complaint same things or the different things? One is plaint, another is complaint. No need to open the browser and just Google what is the difference between the plaint and the complaint. I am just asking a very simple one word answer. I don't need any kind of explanation. I know the whole answer. So please, just relax and tell me what is the difference between plaint and complaint. You can unmute yourself. 26 participants are there, including me and Legal Vidya. And among the 24 participants, plaint is the civil trial, complaint is the criminal trial. Normally complaint is done in criminal matter. Sony, you have written a half of the thing. Complaint is in CPC, complaint is in CRPC. Now, Vani, it's not CRPC, it's BNSS. Complaint is drafted in the civil cases and the complaint in the criminal. You people are good going, you have the conceptual clarity, but there is a lack of the legal vocab actually. When someone is asking what is the difference between plaint and the complaint, you have to clearly mention the suit filed for the civil cases, civil trial civil cases is the plaint. The suit filed for the case filed for the application filed in the court for the criminal thing is it's a complaint. Plaint initiates lawsuit, okay, and the complaint initiates the investigation, okay. And what about the Anmol revision then? Revision we studied both in both. If it is that's why I asked you never to refer the Google, because in our law there is no such term like lawsuit. In the American law, it's a term like a lawsuit. And complaint never initiates the investigation. Investigation is earlier happened. It is already started. Once the FIR is registered, then the investigation is started. So on filing the complaint, the trial begins. Just be with the basic knowledge of the facts. Okay. Yes. In between, anyone have any question, doubts? And Vani, please correct it. It's not CRPC now, it's BNSS. You have to be acquainted with the latest terms. And nothing is like criminal matter, Sir Mohammed Hani. It's like a criminal cases. Okay. And yes, please make just recite once you all verification that is mentioned by the advocate Sakshil. Its verification is a part of a complaint, part of a plaint or a statement to state whether the whatever is stated on this behalf is true and he holds the knowledge about it. So this is the first draft of the same. Now I'm wait for a second. I'm just sharing the another screen also for the another draft. Just be in the class, wait for a second. And before that, if you want to ask something regarding the same, then please put in the chat box. You people have to acquainted with the law vocab. You have to just revise the terms. At least go through the PDFs what I'm sharing, so that you must be just like okay, acquainted with the terminology. The terminology plays a very crucial role. Wait for a second, I'm just sharing the screen. Might be visible, then gives me a thumbs up. The screen is visible. Okay. And the most important thing that everyone who are presenting over here, I am just sharing the screen, whatever I have shared to you. I am not sharing something else, something extra that I have not been shared to you till now. So please, if possible, if you have the time to 5 to 10 minutes after the class, please go through the PDF so that there must be some outcome of you are taking the classes, you are paying the fees for the same, you are taking the stress to join the session on the daily basis. So please just get some knowledge from the same. It shouldn't be just like okay, you have done one more certificate is added. Just gain the knowledge as much as possible. Just try to figure out where you are lagging, where knowledge is lagging, and try to clear your doubts. And please give a time to that 5 to 10 minutes to study whatever is discussed in the daily class, because along with the class only you can learn, else you know no one gets any time to learn in the particular time daytime. Okay, now we will jump into the another draft for the day, and another draft says for the rule number 9, and under the order number 9, this is also for the restoration of suit where the suit was dismissed in the default of the plaintiff. There is also a thing. Okay, one question will be coming into your mind, that why there is a need for the order number 9, why there is a need to, either it's just a suit is being dismissed, either it's just the non appearance of the party. So in Prachi is saying, okay, Vani, yes, Vani. Prachi is saying, ma'am, can you please brief us the difference between the three basic terms, plaint, suit, and petition? and when to use which one. Yes, Prachi, sure. I will just give me 1 minute. I am just completing this draft. Then we'll let you acquainted with each and every term when you use the plain suit and petition. Just wait for 5 to 7 minutes. Okay, Prachi? Yes. And now it's the draft. Yes, I was discussing about why what is the relevancy, what is the utility of order number 9, and when it's just all about that either for the restoration, either for the ex parte decree, either for so what happened, why there is a need to. So for that I would ask you to just go for a hypothetical situation, and then we will come to the conclusion that why there is a need for the order number 9. So first of all of you imagine that you and one of your classmate is just like had a fight. Okay, it's a very common thing these days. So you both decided to complain. You decided to complain of each other, or any one of you have decided to any of the teacher. Now after teacher and just principal has just your listen to your matter and just call the all of the remaining students who were there in the class and to give them the opportunity to present their side. Now he comes and present his case. When the teacher is listening to both of the argument, then the principal also called to do some work, and she asked that you should come tomorrow with your batchmates or with your colleagues or whatever. Now, the as per the order, you present in front of her, but your batchmate was absent. Now, what would happen in that situation? What you will do? So, will the teacher will be able to resolve the fight because there is a lack of the facts, lack of the evidences, lack of the everything. Then what if the absence of the batchmate is, does the teacher must punish that person or not? The second party is not being heard, or he was absent due to some reason. Then what would happen in those cases? Who will get the immunity, or the anyone should get the immunity or not? Next day, what happened? Your teacher was questioned by the batchmate that he punishes him for the misbehavior. Now, do you think that the must be batchmates must be given a chance to state the absence of the same or not? So these are all the questions that are being dealing with the order number 9, rule number 7, 8, 9, and 10. So in that situation, what happened? That the court can, if the defendant is not there during present there during the hearing, then in that situation can the court proceed to pronounce a final judgment? No, no court can't proceed. But then you tell me, how many of you are agreeing for the same, that if the situation is there that the defendant in a civil suit is not present for hearing, the court would be able to pronounce the judgment or not? Or the we can say the defendant must be given the chance to prove his innocence? Okay, Sony. How many of you saying it's no? Because it should be given chance. Yes, Prachi. Because of the violation of Audi Ultram Partum. Okay. Yes, so dear students, this is only the thing. That's why we discuss about the order number 9 of the CPC. That particularly discuss about the disappearance. That particularly discuss about the non-appearance of the party while hearing of the suit. Okay, so these are the basic things. Now, what happened? Now the thing is, if no, neither of the party is there that is available, then in that case the court under the same law order dismiss the suit. But if there is any kind of a limitation is there, that limitation is applicable, then the application to be set aside and the aside the ex parte decree. Now this is all about the that is being order number 7, rule number 9, basic law. Now we jump into the draft directly. Now, draft directly, when we jump into the draft, it's the same as the in the court of application number is this, and application is this. Now, wait for a second. Yes, it's a suit number is this, plaintiff is this, defendant is this, followed by the rest application is being filed. The subject is this. Next is the application for the restoration of the suit dismissed and the on the default on this date under the this year. Now the sir, the most humbly show it with you, the most respectfully, the plaintiff submitted in the law. Now it's what that you have to mention about the facts. Now, facts is there that the suit was fixed for this thing, and that this evidences was this thing, circumstances were this thing, that not able to present in the court. The reason was this. According to the plaintiff, requested the court to wait till Tarhar, but however, the court dismissed the suit in the default of the plaintiff. So these are certain points where that what are the facts of the case, what are the things happened. Now comes the prayer. In the prayer, what you will mention about what is the remedy you are looking forward, relief you are looking forward, then you have to mention that, and you can use these same words and formats for the same. Then the applicant to the advocate and so on. So this is all about the draft of the uh, that is the order number 9, rule number 9, application. Okay. Anyone have else any query? Then please ask. Yes, Prachi. Now we will jump to the your question. Yes, today's drafting is all done. Now we will come to the question. Where is Prachi? Your question is the please. Acha, okay. Prachi, please re-mention your question because it's okay. The first difference between the basic term lawsuit and the petition. First of all, we will take the term that is a lawsuit that is also being mentioned by the Anmol. Look, Prachi and there the Prachi and other all the participants also. Lawsuit is not defined as such under our law, Indian law. It's defined under the American law. But a lawsuit is also the word being used. So when we are discussing about the civil proceedings, then the lawsuit means it's a kind of a legal action. That means you are taking or means that the plaintiff is taking any of the action against the defendant. Now what would happen that if the plaintiff is taking any of the action against the defendant, then we termed as the plaintiff, and the person who is filing the plaint is known as the plaintiff. So lawsuit, you can already see that there is a means that the dispute between two parties. Then what would happen? Then one of the party approach the court to seek the relief from the another party. So the person who is the party who is approaching the court is known as the plaintiff, and if they are filing some of the legal documents, legal aspect for the same, then there is known as the suit, or that is known as the lawsuit. But lawsuit is not defined in a law as such. Now comes the another term. That the another term is related to the plaint. Plaint, particularly plaint is also the same thing. Plaint is defined by the CPC also, and it means that the plaintiff or the person is just bringing the any kind of a suit or any kind of a we can say claim, that document that is containing the claims, that is containing the bring by the person that is known as the plaintiff. Now the suit plaint is covered under the order number 7. Now comes the another thing, that is the petition. Petition is a very wide term actually. Petition you can use everywhere in the so many senses. Petition you can either use for if you are filing uh, petition is just like you are filing for the remedy or kind of a thing. Petitions are particularly it's just under the CPC only these are defined. But when the petitions is filed, then there is a thing like the notice is being received by the defendant also, and it's said that if on the following grounds you have to appear in the court. So petition is also a kind of bringing the legal document, bringing the knowledge in the court, knowledge of the bringing in the knowledge of the court that this thing happened, and there is such thing is there. And the petition holding another different meanings under the CPC law. For example, it also holds the meaning under section number 11, section number 47, so on. So petition is means that the court there is a kind of a legal terminology, while the petition is just like a suit you are bringing to the court of against the defendant. It's just as there is no as such term. I hope you got the concept. Yes, anyone else have any question regarding same? And if you get the point, then please either give us a thumbs up. So it might not be like that it's a monologue session. I'm not turning on the camera because I'm not still feeling good. I'm still not feeling well. That's why. Yes. Anyone else? No one have any query. Yes, Prachi, Sony, and who are there? Only two people are visible. Everything is clear to you all, then please give us a thumbs up. If not, then please give us a thumbs down. Okay, Akash. Okay, Akash, I got you. Anmol, okay. I think, madam, sometimes difficult to identify which term is used to either plaint or the petition. If you are filing a application in the court, I best is to use the plaint word. Go as per the law, as per the rule. Best to use the plaint. Actually, all are the synonymous terms. There is no such difference between the same. It's just like the yes synonym. Yes, Vani, it's a synonymous. You were typing and I was speaking. Absolutely, Vani. Anyone else have any query? No one have any query, then please give us a thumbs up. We'll ask the legal Vidya to wrap the session because I'm just my throat is start paining. Madam, ma'am, which all documents require the affidavit? All the documents under the civil proceedings require the affidavit. Whatever the documents are being filed in the civil court require the affidavit with themselves. They are will not be acceptable by the court without the affidavit. All the documents, Prachi. And all the documents means what? Either all kinds of application. It's a revision application, restoration application. It's a plaint. Everything requires the affidavit. Any kind of application that you are moving to the court. Okay. I think that's all for today. Because I'm not able to speak more. And thank you so much for joining the session. I would like ask Legal Vidya to please wrap the session. Thank you. Happy weekend. Happy learning. Take care. Stay safe. Stay healthy.
Thank you so much, ma'am, for making this session so interesting and knowledgeable at the same time.
Thank you.
Also, I would like to request students to be more interactive in the class so that we get to know more in depth about the subjects we are learning here. And thank you everyone for joining this session. Now you may leave. Thank you once again, ma'am.
Thank you, Legal Vidya. Thank you, dear participants.